We like to make sure that entrepreneurs are informed on the law. And if we're talking about entrepreneurship and the law, we're talking to Mark Furman of Tarlow, Breed, Hart, and Rogers. Welcome, Mark.
Well, great to be here, Jeffrey. Thanks for having me today.
Great. It's my pleasure. I hope you like our new studios. I know you weren't a fan of the old mics.
These are great, and it's great to be here in Boston. And I wanted to chat about an important decision made by the General Counsel of the National Labor Relations Board recently, where the decision was made that McDonald's, as the franchisor, will be considered to be a joint employer of its franchisees in 43 different cases that relate to employee protests. And the General Counsel has authorized issuing a complaint against both McDonald's and the franchisees. So just stepping back for a moment, the franchise world is so prevalent in the business world in our country, and McDonald's was one of the leaders in this area. And under the franchise system, if a company comes up with an idea and they decide to basically sell franchises where they maintain certain controls over how the business of the franchisee is conducted and collect royalty fees based upon revenue and, they supply various products and the like. There's so many franchises in our country, thousands and thousands and thousands.
And more starting every day.
Right. So here we have a employee protests at various franchisees of McDonald's. So the actual hiring and firing and the responsibility for complying with the various employment laws is on the part of the franchisees traditionally. But there is this concept of joint employer where under certain circumstances a company that is not providing the W-2 to the employee can be considered to be a joint employer with what I'll call the real employer. But this movement has not really hit the franchise world in a big way. But this decision of the General Counsel, if upheld, will be just be an earthquake in the franchise world, because it will make the franchisor responsible for conduct of the franchisee in a way that it hasn't been before. That's critically important when you think about how complicated the employment laws are, the wage laws, how employees are classified. If the employer can be jointly liable, if the franchisor can be jointly liable with the franchisee, it really turns franchising on its head, because one of the benefits of a franchise system like McDonald's traditionally for the last 50, 60 years is they collect the payment for you to become a franchisee. A lot of the legal responsibilities are on the franchisee, and the franchisor has only contractual responsibilities to the franchisees. So this creates a level of liability, potentially.
Joint liability.
Joint liability that was not foreseen by franchisors as they put together their franchise programs and enter into the many tens of thousands of franchise agreements that exist in this country. Just think about how many franchisees there are of McDonald's franchises alone. It's really, the implications are staggering. So it's a case that I think we need to follow to see what its impact is And I wonder how this is going to affect franchise relationships going forward.